Do we both have to file for divorce in California? No, California has always allowed one spouse to file alone, and that's still true today. What changed, as of January 1, 2026, is that agreeing spouses now also have the option to file together. Here's how both paths actually work. Start with the traditional process, since it's still the default. One spouse, called the petitioner, files a petition, Form FL-100, with the county superior court and pays the filing fee. That spouse becomes the petitioner, the other spouse becomes the respondent, and the case moves forward whether or not the respondent ever participates. This single filer structure is why California is described as a no-fault divorce state. Filing doesn't require the other spouse's permission or agreement. After filing, the other spouse is served with the papers by a person who isn't a party to the case, and a proof of service goes to the court. The respondent then has 30 days to file a response, Form FL-120, or to not respond at all. If they do respond, the case moves forward with both sides involved. If they don't, the case still proceeds. Since January 1, 2026, there's a second way to start a case. Senate Bill 1427 added the joint petition, Form FL-700. Spouses who agree on every term of their divorce or legal separation can file together, appearing as Petitioner 1 and Petitioner 2, with no respondent at all. Filing together changes a few things procedurally. There's no service of process, since the joint petition is deemed served on both spouses the moment it's filed. It's one combined filing fee of $870, covering both spouses' court costs, compared to a filing fee, generally in the $435 to $450 range, for the spouse who files alone. And the joint petition only works if both spouses agree on every term before filing. It isn't available if there's disagreement on even one issue. Neither spouse can request a temporary court order while a joint petition is pending, unlike the traditional process, where either spouse can request one at any time. So what happens if a spouse won't participate at all? The case can still move forward. If Form FL-100 is filed alone and the other spouse is properly served, but doesn't file a response within 30 days, the filing spouse can request that spouses default, using Form FL-165, and continue the case toward judgment without their participation. California's no-fault structure means a spouse can't block a divorce by refusing to engage. They can only affect how contested terms get decided if they do participate. This is the clearest reason the joint petition doesn't replace the traditional process. Filing together only works when both spouses actively cooperate. Filing alone works whether they cooperate or not, which is why it remains the standard path when a spouse is unreachable, unwilling to engage, or when there's been domestic violence or a restraining order between the spouses. Does it matter which spouse files first? Not for the underlying outcome. California is a community property state, and property, debts, custody, and support are generally divided based on the facts of the situation, not on who filed the paperwork first. Filing first mainly settles a few procedural details: whose name appears first on the case, who arranges service, and which county's superior court hears the case if the spouses live in different counties. It does have one practical effect, though. In the traditional process, the spouse who files controls when the case opens, and the 6-month waiting period generally starts running once the other spouse is served. So filing sooner starts that clock sooner rather than waiting on a joint decision. Either way, the underlying paperwork, whether it's a single filer petition or a joint one, needs to be complete and consistent for the county superior court to accept it. Virdix's guided questionnaire covers both Form FL-100 and Form FL-700, so the paperwork matches whichever path fits how you and your spouse are approaching the case. Virdix is a document preparation service, not a law firm, so this is not legal advice, and for advice about your specific situation, talk to a licensed attorney. You can start at Virdix, Co.